Hello, good morning, everyone, and welcome to this webinar with the Spain U.S. Chamber of Commerce and also with Alan Dyer, Doppelt, and Gilchrist. Today, we are going to talk about a very interesting and trending topic, which is how to avoid copyright infringement liability in the age of social media. Everything is shared in the websites and through internet, so it's easy for everyone to use a lot of documents and materials that might be subject to copyright. So today we're going to clarify many things that everyone could be affected by that. But before starting, I just wanted to thank Alan Dyer, Double and Gilchrist, and Stephanie Vasquez to be here with us and join us to talk about this topic. And also, I just wanted to thank everyone to join us today. I just want to remind everyone that if you would like to participate with us in future webinars that we are hosting, please check all our activities in our website, which is spainuschamber.com, and you will be able to find there at the events tab everything that we are working on. So we have several very interesting webinars scheduled for the following weeks. So I suggest you to pay a visit to our website and check that out. Also, before starting, one thing, we are going to do a presentation. Stephanie Vasquez will go through this topic for about 40-45 minutes. And after that, we are going to address several questions that you, the audience, are going to be able to send us all along this presentation. So you will be able to send your questions through your control panel. There should be a control panel in your screens on the right side of the screen, and you might be able to see a tab that says questions. You just need to click there and send your questions. We will receive all the questions and we'll take care of them at the end of the presentation. But you are able to send the questions during the whole presentation, so you don't need to wait until the end. And well, without further ado, I'm going to do a brief introduction about our partner today, Alan Dyer, Doppelt, and Gilchrist. For over 45 years, this firm has been a formidable presence in Florida law, specializing in intellectual property and complex business litigation. They provide legal services to a range of clients from individual entrepreneurs to national and international corporations. The practice areas include patent, trademark, and copyright prosecution, licensing and litigation, as well as computer and internet law and entertainment law as well. They appear before the United States Patent and Trademark Office, arbitration panels, and administrative bodies, and state and federal courts throughout the country, and they have offices in Orlando, Miami, Winter Springs, Tampa, and Jacksonville. Stephanie Vasquez, which is here today with us, is a bilingual registered patent attorney focused on high-stake intellectual property litigation matters. It's a Miami native, fluent in both Spanish and English, and she represents a variety of domestic and international clients in complex patent, trademark, copyright, and trade secret disputes with cross-border implications. Ms. Vasquez's litigation experience includes not only federal and state proceedings, but also trademark trial and appeal board proceedings. She graduated cum laude with a certificate in intellectual property law from the University of Florida Levin College of Law, where she graduated in the top 15 of her class. And now, without further ado, I introduce Stephanie Vasquez. So Stephanie, thank you so much for being with us today. We'll leave the floor to you.
Thank you, Juan Carlos. I appreciate it. Well, good morning, everyone. So today my presentation is on how to avoid copyright infringement liability in the age of social media. So to get started, just a little bit of copyright basics. So copyright is a form of intellectual property protection that is grounded in the US Constitution and granted by law for works of authorship fixed in a tangible medium. The United States Constitution in Article 1, Section 8, Clause 8 states the following: to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So this clause contains both the protections for patents and copyright. So this is the origination in our Constitution for these protections. So copyright protects original works of authorship. So this includes literary, dramatic works, musicals, artistic works, such as poetry, novels, movies, songs, computer software, and architecture. This also includes images and photographs. Copyright exists from the moment the work is created. This is not commonly known, but the moment that an author or creator, completes a work and fixes it in a tangible medium, the creator or author automatically obtains copyrights in the works and is immediately entitled to protection. So these copyrights grant the owner the exclusive right to reproduce, distribute copies of the work. Also, they can prepare derivatives of the work and perform and display and broadcast the work publicly. Copyright ownership also entitles the owner to then authorize others to exercise any of these rights. So in order to do so, you need to obtain a grant of rights from the copyright owner. Copyright also covers both published and unpublished works. So for example, let's say you take a photograph, create a novel, poetry, etc. Even if you haven't published it or shown it to the public, you do have copyrights from the moment that you create the work. Copyright does not, however, protect facts, ideas, systems, or methods of expression, although it may protect the way these things are expressed. For example, if you have an idea that will not be covered, but a discovery, for example, that leads to an invention, that invention can receive protection under patent laws, for example, not under copyright. Copyright would only apply to works of authorship. For example, the way the description is set for that invention, or any other artistic works like we had mentioned, poetry example. Copyright protects software, whereas software can be protected both by patents and copyrights. So there's a little bit of a distinction there between the types of protection. But again, copyright does not cover the ideas, systems, or methods of operation. So so you may ask yourself, if copyrights arise automatically, why register copyrights with the United States Copyright Office? So copyrights are necessary in order to bring a lawsuit for infringement of a US work. The copyright owner cannot file a lawsuit to enforce its copyrights until the US Copyright Office has issued a registration. So this is a distinction that is sometimes a little bit hard to comprehend. We have rights, why can't we go to the court and sue? So the distinction here is that you can have a copyright in your work and you can register it right away. If you do so, you have benefits such as the ability to ask for statutory damages when you bring the lawsuit. Let's say you did not register your work right away and you wait until after you find that someone is copying your work, and at that point you register your work, then you do forfeit some of those protections, such as the ability to seek statutory damages. So again, statutory damages range from between $750 to $30,000 per work, and this is determined by the court. However, the damage can be increased to up to $150,000 per work if the infringement is found to be willful. So if there was an intentional infringing or taking of the work and copying. So however, on the other hand, if the infringement is found to be innocent by the court, meaning that the infringer did not know that they were violating copyright law, the damages, the statutory damages can be reduced to a minimum of $200 per work. Copyright owners whose copyrights are registered prior to infringement, have this benefit. This is important because, for example, it can be difficult to prove how you have been damaged by an act of infringement of your work. For example, if someone takes a photo or other writing, etc., and publishes it online, you'd have to show how you have been damaged, whether this has reduced the value of your image or work, or you'd have to show the profits that, for example, this infringer gained by using your image, etc. So this can be a little bit difficult to prove sometimes, and it can make seeking enforcement of these copyrights a bit unpredictable, in the sense that it's hard to do a kind of a cost-benefit analysis of how much it's going to take to enforce these rights versus how much you're able to ultimately recover if you win in a lawsuit. So statutory damages can be very helpful in at least having a basic understanding of how much you're able to recover if infringement is found. So it's definitely recommended that you register copyrights in your works, particularly images, if that's a central part of your business, or other works such as music, etc., or other writing such as computer programs. All right, so social media basics. So social media has been defined as interactive computer-mediated technologies that facilitate the creation or sharing of information, ideas, career interests, and other forms of expression via virtual communities and networks. So some of the most popular social media platforms, I'm sure as most of you know, include Facebook, Instagram, Pinterest, Twitter, LinkedIn. And on these platforms, we share a lot of content, pictures, writings, etc. So it's important to have an understanding of copyright law and how there can be copyright liability implications with some of our actions on some of these social media platforms. So social media has become, again, an essential part of digital marketing and advertising strategies for businesses of all sizes. It's unfortunately no longer optional for businesses to engage in social media marketing. Social media allows companies to engage and communicate with key consumers and increasing customer satisfaction and brand loyalty. Marketing via social media outlets also allows businesses to target very specific audiences based on demographics such as age, job title, income level, education, location, or even behavior. An estimated 97% of marketers are using social media, and 78% of their salespeople outsell their peers by using social media for their businesses. So again, social media is becoming very important, and marketing practices, in particular on social media, are key to the survival of many businesses, especially with the current global situation with COVID, etc. So people are becoming much more reliant on sales and marketing, etc., through social media to target their audiences and for consumers to actually make purchases, etc. A lot of it is now occurring through the internet and social media, etc. So there are some dangers associated with social media use. As I mentioned, so social media has blurred the lines of what constitutes a permissible or impermissible use of a work of authorship. So this has created pitfalls for many businesses which have inadvertently fallen prey to copyright infringement lawsuits. Social media has revolutionized communication by providing a platform through which almost anyone can instantly publish information and publicize almost anything to the masses. Every social media user, whether an individual or company, is in essence a publisher, and and may publish content without consideration of existing copyright laws. Social media encourages users to publish content and share the content of others. However, such practices can expose users to copyright infringement liability, particularly when done to promote or advertise a business. So again, when we're on social media, we're sharing, images and posts of others. We're also, creating our own and modifying perhaps images that we found online. And many businesses are using, for example, viral images, etc., to promote their business and advertise their sales and kind of hop on the latest trends. But again, we must be cautious of copyrights and the rights of the creators of this content, even if it's a viral image or something we've seen online 100 times, doesn't mean that you're free to use it just because it's online. So again, this is one of the common misconceptions. The common misconception is the misunderstanding that things that are found on the internet are in the public domain and free to use. Many believe that they are free to publish images found on the internet without permission of the author or creator of the images. But again, this, however, is not the case. As previously mentioned, authors have copyrights in their works from the moment that they are created, even if they're not registered with the US Copyright Office. Generally, copyrights, as a general rule, for works created after January 1st of 1978, copyright protection lasts for the lifetime of the author, plus an additional 70 years. So this can be a very extensive amount of time, and especially in today's world where content and media is created so quickly and so frequently, and it's very likely that the copyrights have not yet expired, as they do take an extensive amount of time. So another misconception is the idea that an image, if found online, if it doesn't have a copyright notice on it, it is part of the public domain, or there are no longer copyrights in the published work. So that is not true. For works published on or after March 1st of 1989, it is not required that they have a copyright notice, such as the circle C symbol, as you can see in the presentation. It's not necessary for images to have that, or other works to have that, in order to retain copyrights in the work. So again, we can't assume that just because those notices don't exist, that the authors are not claiming or are not going to try to enforce their copyright protections over their works. So copyright fair use. There are situations under which you are allowed to use a work without the permission or authorization of the author. And this is a limited exception. This is called fair use, and this is a defense to, for example, an accusation of copyright infringement or copyright liability. So fair use is a legal doctrine that promotes the freedom of expression by permitting the unlicensed use of copyrighted works in certain circumstances. So this protection is embodied under Section 107 of the Copyright Act, and it provides a statutory framework for determining whether something is fair use, and identifies certain key types of uses. So this can include uses for criticism, comment, news reporting, teaching, scholarship, and research. As examples of these activities, these are some of the examples. Key factors that are considered by the court when they're evaluating whether or not fair use is applicable as a defense are the purpose and character of the use, whether the use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantially of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the market for or value of the copyrighted work. Again, fair use is a defense. So, for example, if you or your business are accused of copyright infringement, this would be a legal doctrine that you could bring up as a defense. Again, this is something that would be established after the plaintiff establishes that there was an infringement. You could then assert fair use as a way of defending against liability under copyright law. So businesses and celebrities have found themselves subject to copyright infringement lawsuits for use of images on social media without permission of the author of the image. Despite the prevalence of these issues, there is very limited case law available on the issue of copyright infringement in social media, as most cases settle out of court. So this is very important. Many of these cases do settle out of court, mainly because of the cost of defense of some of these cases and the types of damages, et cetera, that can be recovered. So often the parties settle out of court instead of, engaging in these long legal proceedings to ultimately get a decision. And this is detrimental in the sense that there's very little in terms of legal opinions about how some of these types of situations, such as the use of images commonly used in memes, etc. There's very little in terms of legal opinion of how these cases should be interpreted and what the outcome of these types of cases should be. So many of the disputes that arise, again, out of concerning copyright infringement concern the use of popular memes and the use of photographs that are shared or posted on social media without the permission of the author. Also of note, the use of social media platform, the terms of use of social media platform govern a lot of the copyright protections and other intellectual property protections that you retain once you have posted images or content online. Social media platforms try to minimize their exposure to copyright lawsuits. Also, they include in their terms of services provisions that define the ownership of intellectual property, and this typically affords the platform a royalty-free, non-exclusive license to host, use, distribute, modify, copy, publicly perform or display, translate, and create derivative works of your content. So we're going to walk through some of these terms of use so you can see what we're talking about. So Twitter's terms of use, for example, provide that you as a user, you retain your rights to the content you post, submit, or display on or through the services. However, it says by submitting, posting, or displaying content on or through the services, you grant us a worldwide non-exclusive royalty-free license with the right to sub-license, use, copy, reproduce, process, adapt, modify, publish, transmit, display, and distribute such content in any and all media and distribution methods known or later developed. So again, this is a license that authorizes Twitter to use your content without providing any other sort of compensation or need for any other type of license. So that is the case in terms of Twitter. Facebook also has a similar provision. Facebook provides that you own your intellectual property rights in any content that you create and share on Facebook and other Facebook company products. However, you do grant Facebook a non-exclusive, transferable, sub-licensable, royalty-free, and worldwide license to host, use, distribute, modify, run, copy, publicly perform or display, translate, and create derivative works of your content. So again, very similar to Twitter, you're providing Facebook the ability to use these images or content without them risking the potential copyright liability if they do use your work or publish your work. Again, Instagram is a Facebook company, but it similarly provides that when you share, post, or upload content that is covered by intellectual property rights, such as photos or videos, on or in connection with our service, you hereby grant us a non-exclusive, royalty-free, transferable, sublicensable, worldwide license to host, use, distribute, modify, run, copy, or publicly perform or display, translate, and create derivative works of your content. Similarly, LinkedIn also has a worldwide license that you provide once you're providing content information on their websites. So now we're going to go through some of the disputes relating to memes and images on social media and online blogs, etc., that can be pretty instructive in getting a sense of how issues can come up in terms of using these images without the permission of the authors of these works. So one of the first disputes that went viral regarding the media has to do with the socially awkward penguin meme. So the original image of the penguin is the intellectual property of National Geographic. So approximately in 2015, the company's licensing agency, which is Getty Images, they started going after multiple people that were publishing this image on the internet, and required that the companies that they went after agreed not to disclose the fact that they had approached them or that the companies had reached a settlement with them. So in one particular instance, Getty tried to collect $900 in back licensing fees from a German blog. So just for a little bit of explanation, back licensing fees, when these are, this term means the licensing fees that you would have paid had you asked permission in the first place to be able to publish this image and make commercial use of this image. So they tried to collect $900 from this German blog. The owners of this German blog spoke out about the dispute, and this caused a big debate about what the internet creativity, ownership, and culture should look like. Ultimately, again, these disputes settled, but this was one of the kind of first controversial cases of meme usage and how that can turn into copyright liability and the need to pay damages to kind of settle this dispute. So another interesting case was relating to Trump and this ad that was put out by Trump's son, Donald Trump Jr. during the first presidential campaign. So during the first campaign, the campaign was hit with a copyright infringement lawsuit in the Northern District of Illinois, and it was brought by the photographer that took the image of the bowl of Skittles that's pictured there in the ad. Again, one of Trump's sons used the image to create this post that illustrates the supposed dangers of Syrian refugees in the United States. This case was ultimately dismissed by the plaintiff after reaching a settlement agreement. But again, this is one of the unfortunate outcomes of using images without the permission of the author. This is another case related to memes. In late January 2020, Lainey Marie Grainer, she's the mom of the little boy known across the internet as the Success Kid. He's pictured in the ad, with a clenched fist and a very determined look on his face. So Lainey Marie Granger, she sent a cease and desist notice claiming copyright infringement to an Iowa Republican representative, Steve King. So Steve King was using this ad as part of fundraising efforts for this campaign, and Lainey Marie Granger took to the media and sent a cease and desist letter calling the man vile for using the viral image of the toddler as part of the fundraising efforts. The ad was taken down. It doesn't seem like it turned into an actual lawsuit, but it seems that the parties quickly reached a resolution. This is another case relating to Ludacris and the boob sweat meme. So in June of 2017, an online publisher sued Ludacris for alleging also cyber privacy over a meme posted to the rapper's Instagram account that used the company's illustration of a woman applying deodorant to the underside of her breasts. So Ludacris posted this meme, which uses the illustration from the article. He posted it in March, and he added to the memes the words, "It's that time of the year again." And he was hit with a lawsuit shortly thereafter. The lawsuit lasted for quite a while before it was voluntarily dismissed in February of 2018. Again, this would have been an interesting situation to see how the court would have come out, whether or not it would have found that this was a fair use instead of, you know, a use that would subject Ludacris to copyright liability. So another kind of series of meme disputes have to do with Pepe the Frog. So the Pepe the Frog creator, Matt Fury, sued InfoWars for selling posters featuring the character. For those of you who aren't familiar, InfoWars is an infamous multimedia outlet founded by far-right radio host and notorious conspiracy theorist Alex Jones. So InfoWars claims fair use, arguing that their widespread memification of the character meant that it was accorded less robust copyright protections. So again, they tried arguing that, you know, the image had gone so viral, it became a meme, and as such, it should be afforded less copyright protections than other images. So in May, the U.S. District Court Judge Michael Fitzgerald didn't buy the argument. He wrote that defendants have not pointed to any authority for the proposition that memification of an image or character destroys or diminishes the author's copyright interests. The judge also rejected the argument that fair use, when raised by controversial defendants, ought not to be decided by juries and should be afforded special First Amendment treatment. So again, this particular order by the judge sheds a lot of light on whether or not a meme or image that has gone viral will be afforded less copyright protection. This judge does not believe that that is the case. So again, even though I guess the public in general may not feel that, you know, memes and viral images can be afforded as much protection, that's not the case in terms of how the district courts are coming out on these issues. So ultimately in June, InfoWars opted to pay $15,000 to settle the case rather than proceed to trial. So that was the end of that dispute. This is another case. This has to do with a meme that pictures a kind of text conversation. The content creator accused Jerry Media of screenshotting a joke that he had told on Twitter and reposting it to Instagram as an ad for the agency's tequila brand. So the infringer reposted the joke and then added the caption, "Me after my 6th glass of at Jaja Tequila," which again is their tequila brand. So they were using the meme to promote their tequila brand. This Jerry Media is the ad agency that has been under the microscope recently after a disastrous incident in 2017 relating to the Fire Festival. The case was ultimately voluntarily dismissed by the plaintiff. Again, this tends to happen after the parties have reached an agreement and decide not to move forward with the lawsuit. But again, it would have been interesting to see how this case would have turned out and whether or not there would have been a finding of fair use. So this is another lawsuit. This was a lawsuit brought by a Florida photographer against LeBron James. So this was after LeBron James posted on Facebook a photograph of himself that was taken by the photographer while he was dunking on Miami and while he was with the Lakers. The complaint states that James reposted a copyrighted image from a December 13th game between the Lakers and Miami. In August, James countersued, alleging that the photographer violated his state law rights of publicity, claiming that the celebrity's rights to control his own commercial use of his name, image, and likeness. His attorneys wrote that Mr. James has never licensed or otherwise permitted the use of his image or likeness for any purpose to any plaintiff. It says that the plaintiff has exploited Mr. James's rights and likeness to promote plaintiff's photography services. Again, this is a very interesting take on defending against a copyright infringement lawsuit. James again took the image of himself without any license or permission from the photographer and posted it to social media and tried to defend against it by saying that the photographer didn't have a right to use his image or likeness. Again, this case is still ongoing, and it will be interesting to see how the case turns out as to copyright infringement liability and James's claims of the rights of publicity. So we will see how that turns out. So this is another lawsuit. This involves Katy Perry. So in October 2019, she was photographed by a celebrity news agency. She was sued after she posted a photograph of herself in the costume dressed as Hillary Clinton. She posted it to Instagram in 2016 without the permission of the photographers of the news agency. So she got sued, and to fight the case, Perry raised another interesting argument. She argued that the elaborate costume itself was copyrightable, meaning that the photograph that was allegedly infringed was just an unlicensed derivative of that work. So she claimed that, by putting this costume on and all these, makeup details, etc., she created a work herself, and by taking a photograph of her and her work, this created infringement by the photographer when taking the photo. So it wrote that the entire appeal and content of the snapshots are based on their unauthorized incorporation of the underlying artistic creations that make defendant and her companions unrecognizable, and instead appear as Bill and Hillary Clinton and a Trump troll in the back, she wrote. So those underlying artistic creations are themselves copyrightable: the hair, the makeup, prosthetics, wardrobe, and mask. So again, very interesting defense or take against these claims of copyright infringement. This is another lawsuit. So supermodel Gigi Hadid was sued in January 2019 after she posted a cropped version of a paparazzi photo to her Instagram page. Again, this photo was visible to her 43 million followers. In the months after the case was filed, Hadid asserted several defenses, including that she had an implied license to use the photograph because she had stopped to permit the photographer to take her picture and had thus contributed to the photograph's protectable elements. So she claims that she too is an author of this photograph because she stopped and posed and contributed to the copyrighted work, and as such, she had an implied license to use the photograph. Again, this case was dismissed in July 2019 for another reason. The judge cited a recent Supreme Court ruling that the owner had failed to properly register the photograph with the U.S. Copyright Office before suing. So again, it's very important to register your works before you sue in federal court, as that is a prerequisite. So this case was ultimately dismissed on that basis. But it would have been interesting to see how the court would have reacted to her argument about her posing and stopping. All right, so this is another case. This is model and actress Emily. She was sued in October 2019 over an Instagram story where she used a paparazzi image of her carrying a large vase of flowers down a New York City street. So again, this was posted to her Instagram story. If you're not familiar, Instagram stories last for 24 hours. So it's not something that was published online for an extensive amount of time. But nonetheless, she was sued on October 9th in a motion for summary judgment. She argued that she was shielded by copyright's fair use doctrine because she had entirely transformed the image by adding the words "mood forever" to her post. So she claims that she modified the image by adding the caption below "mood forever," and that under the copyright fair use doctrine, this would afford her copyright protection, copyright liability protection. Again, her attorneys wrote that the objective of the original photograph was to exploit her fame with an unoriginal and accidental paparazzi photograph. The objective of the Instagram story was to make commentary and criticism from her perspective of abusive, aggressive, and harassing practice of paparazzi continuing to follow her even when buying flowers for a friend. So again, she's claiming that it's fair use because her photograph is a commentary or criticism of the paparazzi's harassing practices towards her. So it will be interesting to see how this turns out. Another key lawsuit recently has involved Moschino and Cardi B. So a Los Angeles-based photo agency sued Moschino and Cardi B for their use of an image of Cardi B wearing a Moschino jacket without license from the owner. So they claim that Moschino copied the images from a Daily Mail article and posted it to social media to promote their products. Cardi B also posted the photograph without permission, and both were sued. In response to the copyright infringement lawsuit, Moschino countersued for copyright infringement, alleging that, again, similar to the Katy Perry case, that the floral Moschino jacket that Cardi B was wearing is a visual material that it had registered the design with the U.S. Copyright Office in 2018. So similar to that Katy Perry lawsuit, they claim that the photograph is an infringing of their copyright protection in the actual jacket. So this case, again, was ultimately dismissed in its entirety with prejudice after filing a notice of settlement. So again, the parties reached an agreement and the case was ultimately dismissed, but it would have been interesting to see how this would have turned out had a jury or the court made an ultimate determination as to infringement. So again, we need to be very cautious when using photographs on social media or on personal websites, business websites. There are these what are called reverse image search softwares. These include the ones listed here: Pixie, CopyTrack, Image Rights, Image Protect, Image Defenders. So these are search tools that are used by authors and photographers, etc., for to monitor the internet for unauthorized uses of their images. So, even if your website, for example, doesn't have much traffic, these softwares are able to track down use of images, and that's how the photographers become aware that the image is being used, and they then send a demand letter or sue, etc. So it's becoming much more risky to again use images without license. So these reverse image software companies, many of them will first contact you after notifying the author of the unauthorized use. They will contact you and they will send sort of a preliminary demand, and they will ask for a certain amount of money as a, like we explained, back licensing fee for using the image. Again, oftentimes people ignore these initial demands from these companies, but unfortunately, if they're not answered, oftentimes this leads to an escalation of the dispute. These companies then refer the dispute to attorneys, which then again may draft another more formal demand letter or may initiate a lawsuit in the district court. So again, it's recommended that if by any case you do receive one of these a demand or a notice from one of these agencies, that you do address them and contact an attorney to figure out a strategy. But ultimately, if they're ignored, they do tend to become a bigger issue and can lead to the filing of a lawsuit. All right, so that is the end. I welcome any questions that you may have.
Okay, well, thank you so much for that presentation. So we are entering now to the Q&A area. So again, any of the attendees that would like to ask a question, just click the tab that says questions in your control panel and send your questions through, and we will be able to address all of them. So actually, we have some questions already. So while the rest of the attendees send their questions, Stephanie, we're going to address some of the questions that we have. The first one, it's about, well, we saw in your presentation that many of the disputes are already solved before ending in court, and some of them start in court, but they end the dispute outside the courts. So the question is, okay, for a small business that received, for example, a notification from one of those agencies that you just mentioned in your last slide, saying that, well, they require or they demand a certain amount of money for a picture that you used, let's say, I don't know, $300, for example. What is usually a threshold where you should contact an attorney, and then where usually is the range of the threshold where you should go to a lawsuit or to court? Because okay, they're asking $300. If I'm gonna contact an attorney to help me to answer that email, and the attorney is gonna cost me $400, maybe I should pay the 300 and leave it that way, or don't do anything and let's see if they are going to go farther and going to court. Because maybe if they decide, maybe they they say, we are going to court if you don't answer us, but you may know that going to court for them is going to cost them $1,500, for example. So, and maybe they're not going to get more than 300. So, what are the thresholds there? I think not every time you should go to court. And what are the amounts? Those kind of thresholds.
Yes. So as an initial matter, if again, like you said, if they're demanding $300, $400, etc., again, don't ignore the notice, but even if you do decide that you want to go ahead and pay the fee and try to avoid this escalating to a dispute before the court, it's still recommended that you contact an attorney to make sure that the terms, for example, once you pay the $300, that you have an agreement that says, because I've paid these $300, you relinquish all claims against me, that you're not going to sue me either way, because that is a danger, that you end up paying a certain amount of money to settle the dispute, but then ultimately you don't have in writing a full release from this company, and then later along the line another attorney could come out of the woods and file a dispute against you. So it is recommended, even if the case doesn't escalate, to seek some attorney advice and oversight on the negotiation of what you're signing, or what release that they're giving you when you pay the $300 or $400. This can, again, it may cost a few $100s to get that advice from the attorney, but it can save you thousands in the future if they do ultimately file a lawsuit anyways, even though you paid. Again, in terms of threshold, how much money they're demanding from you, and when it makes sense to fight it in court versus settling early on. Sometimes when, like we've said, if they've registered their copyrights for their images very early on, sometimes they'll hit you with a demand that's very high, claiming that you've infringed willfully, and they can get up to, for example, $150,000 in statutory fees. So sometimes their initial demand might be very high. That's usually not the case, but if it is, definitely it's worth fighting. Sometimes once you've shown that you're willing to stand your ground and protect and fight against these lawsuits, the demands start getting lower and lower. Also, it is notable, if you do end up winning, even as a defendant, in the court, there are provisions in the law that allow for the prevailing party to get attorney's fees. So again, that can go either way. If you end up losing before a court, even if the damages number isn't very high, but the attorney spent a lot of money, coming after you, you can be liable for that amount of attorney's fees that were spent in trying to protect the copyright. So it can amount to quite a large sum. So those are things to consider.
Okay, no, perfect. Thank you. We have other question that we received just a moment ago. It says, if you hired a graphic designer to design your logo, are the rights yours or the graphic designers?
Okay, so again, there's usually you enter into a contract with your logo designer. For example, online, there's websites like 99 Designs, etc., where you can have a graphic designer, propose different designs, etc. Usually there is an agreement, a release that all intellectual property relating to that design are now owned by the company. So it is important to try to get those provisions in place when you're contracting with the graphic designer. I mean, usually disputes like that are not very common, because there are ways of say you don't have those provisions in your agreement. There are ways of trying to enforce those rights if the graphic designer does come after you, but it's better to have it in writing early on.
So the best thing is to have it in writing, but if you don't have it in writing, usually those are rights of the company or the graphic designers at the end of the day.
Yeah, if it's it depends on whether the court, you have to show to the court that you have hired the graphic designer for that purpose, and that there's an understanding that the rights would belong to the company based on the compensation that was provided to the graphic designer, etc. So it can become a costly procedure to kind of solidify those rights. So it's better to get those in writing.
Better. Thank you. Another question that we have is it unusual for celebrities to counter-sue because of their celebrity status?
So like we saw in the LeBron James case, the rights of publicity countersuit against the photographer. Again, I don't think that would be a very successful argument to a copyright infringement lawsuit. But again, these are matters that are brought. Usually, the more famous the person is, the lesser right of privacy, etc., that they have. So if they're a public figure, it's more difficult for them to kind of bring those types of claims and claim that photographers can't take pictures of them. Again, we know from our day-to-day experiences that that's not the case. These people get photographed every day, and that's a common occurrence. So I think that those would be arguments that are unlikely to be successful before the courts.
Okay, interesting. We'll see what happens with James' case. Hopefully, they won't get an agreement before, and again, we will lose the opportunity to understand what the court is thinking about it. So we'll see about that.
Unfortunately, it happens more often than we'd like.
Yeah. Another question that we have, I think it's a very interesting question that many people might have as well. It's if my company uses in our website an image from another party, but indicates the source right below the image, providing a link to the page where it was found, could this be considered copyright infringement, or is this fair use?
Okay, so even if you cite to the source where you got it from, for example, you could still be liable for copyright infringement. That doesn't, sometimes we believe, because we've learned about plagiarism, etc., in school, and it's not the same. So if even if you use an image and you cite to the source, etc., it's not enough to kind of get rid of that copyright infringement liability. So no, you do need to see if it's an image that you have to contact the author and get a license. Unless there are certain websites and things that you can find online that have images that are in the public domain, and if you find one of those and you will be free to use those, but for the most part, unless you go through one of those avenues, you want to make sure that you have a license.
Perfect. Thank you so much. Another question that we have, is the data shown in a chart found on the web protected by copyright law? Would it be acceptable to create our own chart with the data and indicate the source? That's nice for presentations. Good question.
So it depends on the data that was collected. If usually, for example, if you're just taking information from different sources and creating your own chart, etc., that is typically a fair use, because you're not using the particular expression of the original author. You're creating your own chart, creating your own writings, etc. It's the same as, for example, when you're doing research and you're reading from different textbooks and gathering knowledge and information. A big part of that is what I had explained previously, that copyright does not protect facts. So any facts that appear in a work, whether it's a chart or otherwise, are not protected. There are some situations where a collection of facts can have its own copyright protection. So depending on the situation with the chart, what information was collected to make that chart, there might be some limited protection to the compilation of facts that make up that chart. But in general, if you're just gathering factual information from different sources and creating a chart, for example, that you make yourself, typically that wouldn't expose you to copyright liability.
And what about the case that I'm, for example, preparing a presentation, and in one slide I would like to show a graphic with the, the increase of purchasing toilet paper, for example, and I found a chart from a company that published that in the internet, because they studied that, they have the data, and they have that nice chart with where we see the data and we see the increase of purchasing of toilet paper. Could I snapshot that graphic and put it in my presentation and use it as a fair use?
Yeah, so it depends on the purpose of your presentation. If it's kind of like a presentation like we're doing now, that it's for educational purposes, you're teaching, it's not for a commercial use, for example, that would typically fall under fair use.
Wonderful. And we have some more questions here. That's it. Yeah. Will this presentation be housed somewhere for later view? Yes, of course. And thank you for that question. I forgot to mention that. We will share the presentation and also the recording of the webinar, so everyone could review that or share with their colleagues and friends later today. And we will also send the contact information from Stephanie, just in case you have another specific question, you can contact her directly. But yes, we will share the presentation and the video as well. Let's see what we else have here. Yes, are the pictures found online via Google or other websites part of a public domain? This is something that you addressed at the beginning. You mentioned that no, and they do not have, they don't need to have the C symbol for that, no?
Correct, yes.
Here say, if my company takes down the allegedly infringing image after receiving a notice claiming copyright infringement, does that resolve the dispute?
Okay, so yeah, again, no, that doesn't resolve the dispute. If it is recommended, if they are telling you that you don't have rights to use the image, etc., it is best to stop use, unless you get a license from the author. But that does not typically make the dispute go away. It's likely that the attorneys will, or the agency that has sent you the notice will still want some compensation for the time that you did use the image, back licensing fees, or would like to proceed with a lawsuit, and they have the right to do so. So again, just taking down the image is not enough to kind of make the problem go away.
Perfect, thank you. We have another interesting question. It's who is responsible for defending against a claim of copyright infringement if the image was selected and published online by a third-party company, which my business hired to assist with marketing or website development?
Okay, yeah, no, very interesting point. So we do need to be careful, even if you're hiring a third-party, marketing person or website developer, etc. Especially, with when you have international businesses, like a lot of us probably watching do have, you want to make sure that your marketing people, your website development people are getting licenses to use these images. If you do receive a notice because there's an image on your website that you didn't get a license for, you will still be responsible for defending against it. You can then go and try to get your third-party vendor, such as the marketing people or the website development people, to pay you back for having to defend against the lawsuit. But again, that would then depend on your contracts with those vendors, etc. Even if it wasn't you that posted the picture, since it is a picture that is on the website of your business or promoting your company, etc., your company becomes responsible for those damages and for copyright infringement. So you need to be aware. usually, in that case, it's good to have, provisions in your contracts with your marketing people and or website development people, etc., that provide indemnification. For example, if you do get sued for something related to images and not having licensing rights, etc. So those are things that you can build into those agreements, but ultimately you will be responsible if an issue does arise. So that's a conversation that you do want to have with those people, especially if you have a company that has websites that are accessible in multiple countries, etc. You want to make sure that any images that you use, you have the rights to use those images.
Great, thank you. And we have here, I think, the last question is, if someone registered the material after infringement and also after those 3 months after the creation, as you mentioned at the beginning, if they go to court and win in this situation where they didn't register previously, and if they win, aren't they allowed to obtain statutory damages or other types of damages?
Yeah. So typically, you have lost your ability to ask for statutory damages, but you do have your ability to get damages for any lost profits to your business, the devaluation of your work, profits that were gained by the infringer by using your work. And for example, if your work goes down in value because it has been used by others, for example, if it's a very exclusive work and now it's been accessed by many people, that can be a factor that gets taken into account in calculating damages.
Okay, great, thank you. Well, I think that was the last question. So thank you so much, Stephanie, for this great presentation. We learned a lot about copyright and copyright infringement. As I said before, we will share this presentation and also the video of the webinar so everyone could see it later if they like and they need it. And we'll also send Stephanie Vasquez contact information. Please don't forget to check out our website, which is SpainUSChamber.com, and you might be able to check there our next events and everything that we are preparing for the following months. Stephanie, thank you so much for being with us today, and thank you to Alan Dyer, Dapple, and Gilchrist.
Thank you, Juan Carlos. It's been a pleasure.
Thank you to everyone. Great seeing you. I hope to see you next time as well. Take care and be safe. Goodbye.
Thank you.